Okay, thank you everyone for joining us today for this first ever webinar on the child's right to identity in family relations. It's a real honour for me to welcome our distinguished speakers. They truly are the leading speakers and leading specialists in the world on this topic, and they've come from all over the world. So thank you to our speakers. And thank you to you as well for making the time to attend this meeting. As you know, identity in family relations is clearly outlined in Article 8 of the Convention on the Rights of the Child. And the spirit of the text really does not limit the idea of family relations to immediate family. It's much larger, it's much broader, given that the grandmothers from Argentina asked to have this added to the text. And now we can see from the way that the Committee on the Rights of the Child has applied this right to identity in family relations in their concluding observations and recommendations, that they're broadly interpreting family in terms of the rights of the child. So without further ado, I'd like to introduce to you Velina Todrova, who is a current member of the Committee on the Rights of the Child, who's kindly joined us immediately from session. She's going to speak to us today about the views of the committee and the way they're dealing with state parties. Over to you, Velina.
Thank you. Thank you very much, Mia. Thank you for inviting me. Hello, Olga. Nice to see you. I will start on my presentation with the initial just words that Mia mentioned, only Article 8 of the Convention, but actually the committee also considers Article 7 and Article 9 as providing for the right of the child to identity in certain aspects. So I will present briefly how the committee views this topic, and then I will give you some examples from the COPs and individual communications from the last 5 years of the work of the committee. Well, the family, we know, plays a fundamental role in a child's development of identity. A child, therefore, has the right to, as far as possible, know their parents and to be cared by them, the right to preserve their identity, including their family relations as recognized by law, and the right not to be separated from their parents against their will, except when it is necessary to ensure the child's best interests. So I went through all these 3 articles as enshrined as rights enshrined in the Convention. States, according to the committee, are responsible to respect, protect, and fulfill the child's rights to identity under Articles 7, 8, and 9, and the committee addresses the violations of the rights to identity related to the family depending on the information it receives from various sources, and more frequently under Article 7, but sometimes under Article 21 adoption. Under Article 7, the child has the right his or her identity related to the family to be established first, and the right to know their parents, and then to be cared for by the parents as far as possible. Regarding this right, the committee considers the role of the systems of birth registration, the right to know and for children being adopted, and children born with regard to artificial assisted reproductive technologies, including surrogacy. Regarding birth registration, the child we consider that the child has the right to have the biological parent to be recognized as a legal parent or as a parent under the law. This should be realized through comprehensive birth registration systems established by the states, and the birth certificate of the child should contain the parents' names, and the child's name should keep the link to parents according to national laws. The proper birth registration actually establishes the legal relations between the child and the family of the parents and their relatives. In case the biological parentage has been split from their social or even from birth parentage under Article 7, the child has the right to know who their parents are. The committee has come to address these issues in cases of children born to unmarried parents, children in vulnerable situations such as abandoned, displaced, or children who belong to ethnic minorities, as well as adopted children and children born after assisted reproduction. You see on the screen some of the issues we had with states regarding barriers to birth registration of children born to unmarried parents, children born to same-sex couples. Actually, children born to same-sex couples is not an issue that has been dealt so far by the committee. We have just one mention. Also, we identified issues for children belonging to ethnic or other minorities, children of nomadic families, indigenous, aboriginal children, and etc. We consider that the violations of rights of this of the right to be related to family mostly come from discriminatory family legislation, traditional view regarding filiation and family stability, which are and the best interests of the child are not considered in these cases, particularly in cases of not only birth registration but also adoption, assisted reproduction. And in these cases, priority is given to secrecy of adoption, to the rights of women or mothers and parents in child, and gaps also exist to reach out disadvantaged families, also discriminated practices towards indigenous or peoples are reasons for the gaps in violations of the child's right to identity under Article 7. Usually, the committee considers right to identity under Article 7 from the perspective of statelessness of children, not so much from the perspective of family identity. But we do consider family identity when we get proper information and also discussion with the government. The committee further systematically criticizes the laws and practices allowing for anonymous birth or anonymous child abandonment. This practice is widespread not only in Europe, but also in some states in Asia. For example, in Philippines, so we discussed the so-called simulated births. Also, we have illegal birth registrations in falsified birth registrations in some European states. We have the practices of baby boxes also in Republic of Korea, and in Japan. These violations are due to social norms about parenthood, stigma, and discrimination of women, and committee is trying to recommend as alternative a procedure for confidential birth services state should ensure information about the biological origins of children is preserved and ready to be accessed by the child. You see on the screen a positive example from the Netherlands, where the practice of baby rooms has been abolished, and children they started this practice to collect information about the mothers with a view to provide access of children to their biological, to know their biological origin. Regarding adoption, as I said, we have the committee has a very strong position on the right of the child to know their origin or their biological parents in cases of adoption, as well as in for children born after assisted reproduction, including surrogacy. When the committee is confronted by secrecy in adoption, we always recommend the state party to ensure access to information. And I provided some examples of different languages that committee applies with regard to different contexts of the state parties coming to review. For example, to Republic of Korea and Vietnam, the committee applied less strong language. As you see, it used the approach to enforce the participation rights of children to know their rights and to seek information. This is what we recommended to these state parties. Other state parties received recommendation to ensure that children has access to information, to establish and also recommendation to establish legal rights of adopted child to know its biological parents. Also, there is the development regarding some countries, state parties that already recognize this right of the child to know its biological parents, to remove legitimate interests as precondition for a child's rights to information. And to one state only the committee applies a very strong language. It recommended Czechia to oblige parents to inform the adopted children about adoption before children reach the schooling age. With regard to assisted reproduction and surrogacy, committee follows the same approach. Even we have stronger language. You see on the screen. The committee urges the states to provide access to children to information about their here we can say genetic parents, and also to build or to start building special registers that could avail children to have information about their origin. Well, I'm skipping recommendations, and I go to Article 8, the right for the child to preserve their identity related to family relations. Here we have, I provided some examples of these rights, being violated. These examples, of course, come from committee's reviews. Changes of names. We identified in 1 or 2 countries that names of children have been changed, which is infringement of this right under Article 8. Then separation from the family could lead to violation of the rights to family identity. Abandonment in alternative care. 1 or 2 states actually there was reported in the reviews that actually there are children abandoned in alternative care. No efforts to establish good contact regimes or measures for reintegration. Illegal adoptions is another area where the committee already expressed its opinion in joint statement issued last year. The issue also came with separated children under the OPIC cases and in children in humanitarian situations. Well, I don't think I need to be very detailed regarding unnecessary removals of children from the family, which may infringe their right to family identity. In this case, we have the Article 9, Paragraph 1 standards of the Convention, and the committee is very careful and very detailed to recommend the states to really remove children only when necessary for the best interest of the child, with all the care regarding best interest assessment and determination, but also procedures should be very strict and rights based. Well, I already said that the states are recommended to create a registry for children in residential care to ensure in cases of abandonment, data collection is really taken care of, full respect, and also particular attention to contacts with families, with parents, and measures to facilitate family reunification. Well, I would just would like to mention this joint statement that the committee issued with the Committee of Enforced Disappearance and other mechanisms. There we have this prevention recommendation to prevent. We recommended inter-country adoptions to be really to follow the principle of subsidiarity and the best interest. Best registration is very important for every child, and higher risk for separation for certain groups of children. What is the remedy? Right to truth, to victims, to really to be assisted to access the information about their origins, and separated children. Two cases we had against France and Finland regarding separated children in North Syrian camps, where the committee actually considered the family links of children, and where the committee found that the family links are established, the identity of family of children regarding their families were established. That for the committee created the link to their nationality, further to the jurisdiction of the state, and further to extraterritorial jurisdictions to protect children and to repatriate children in these camps. And this is my final word, and thank you for your attention. Sorry for being probably too long.
Thank you, Velina. We can see that the committee is very much addressing the question of identity, and we really appreciate that they're covering it from so many different angles. What we have now is we have Annie Ruda Kulkrani from UNICEF, who will be presenting to us on the work of UNICEF and other countries to support families and prevent unnecessary separation. Thank you, Annie, and thank you, Velina, as well.
Hi, Mia. Thank you so much for inviting UNICEF and inviting me to speak today. I hope you can hear me. And I'm going to upload a very brief PowerPoint presentation. Please confirm that you can see it when I upload it. Do you see my presentation?
Not yet, but it should come because we saw it before.
Yes, exactly. very strangely, I can't see it now.
It's okay. We'll wait.
Yeah, give me 1 second. I don't know what's going on.
It's your new computer. It's your new
It's
computer.
it's my new computer.
Maybe, Annie, if you log in and log out, and in the meantime, maybe what I'll do is move on to a next speaker, just so that, because I'm conscious of the time, and then
Sure.
you can find the presentation. And I'm going to maybe put Philip
I mean,
and
I
do you
have it
think you're
open in front of me, but it's just not showing on the screen.
Yep, it's not showing. But let's
Yeah.
move on to maybe Philip and Laura. Sorry, I'm going to put you on the spot, Philip and Laura, but welcome from the Hague Conference on Private International Law. I hope you're both doing really well. Thank you for being with us today to speak about the work of the Hague Conference and the different family conventions that all touch upon this issue. I'm not sure who's going to speak first, whether it's Philip or Laura, and whether you want to do a PowerPoint as well or not necessarily.
Yes, we do have a PowerPoint. Every good day to everybody, morning, afternoon, evening, wherever you are. Yeah, Laura is with us as well. And you want to test your microphone, Laura?
Yes, hello to everyone.
Excellent.
Morning.
Okay, very good. We're on board. Yes, the plan is to have a PowerPoint.
Excellent, we can see it.
Yes, and yeah, if we can just do F5, perfect. Very good. Yeah, thanks a lot for inviting the Hague Conference to say a few words concerning child's rights to identity. What we have for you to do today is actually just an overview of the HCCH work that actually relates in some way or another to the child's rights to identity. And we'll be covering a project, some of you know, Parentage Surrogacy Project, and we will deal with the main child protection conventions that you see on screen. Perfect. General Children's Right Framework in the HCCH Child Protection Convention, in addition to implementing key provision of the United Convention on the Rights of the Child, such as the best interest of the child, Article 3, and the right of the child to be heard, Article 12, the HCCH Children Conventions implement several other provisions of the UNCRC that help children in a cross-border context to preserve and access their identity, including their origins and their family relations. And now I'll leave the floor to Laura, who will take you through a project and a few conventions.
Thank you very much, Philippe. Good morning, good afternoon, good evening to everyone. So I'm going to briefly mention the Parentage Surrogacy Project, the 93 Adoption Convention, and the 9080 Child Abduction Convention, and then Philippe will do the rest of the convention. So regarding the Parentage Surrogacy Project, as it has already been mentioned, identity is extremely important. And in this project, we are focusing on what we call legal parentage. So who are your legal parents? And the idea is that you can, a person, or in this case, a child, can move from one country to another having the same parents. And therefore, if the HCCH arrives to agree on a convention on parentage, including surrogacy, or everything is open at this moment. But if we can have a treaty dealing with parentage, maybe as well including surrogacy, this will help to the cross-border recognition in one state of legal parentage established in another state. Therefore, it will make it much easier for persons from moving from one state to another. And this will also help children to maintain their family ties, because you will not have the problem of moving from one country, having one set of parents, going to another one, and maybe one of those parents is not anymore considered your parent. And as well, this project that is now has been working with an expert group since 2016 to 2022, and which handed in its final report at the end of last year. It also, the expert group that we had for a number of years also looked into the issue of preservation of information and access to information that will be linked as well with identity. These are things that have been discussed. Nothing has been agreed yet, but at least at the expert group level, it was something that was discussed between the different experts in the group. Regarding the 93 Adoption Convention, well, adoption is one of the possible ways of establishing legal parentage, because a person usually will have its legal parentage either established by operation of law, by an act, like an acknowledgement of the father, or by a decision. Usually it could be a judicial decision. And adoption can be one of those. The 93 Adoption Convention in relation to identity, it helps a lot, because the idea is that this convention establishes safeguards against abduction, sale or trafficking, and other abuses in intercountry adoption. And therefore, the legal parentage, the adoption that will be recognized in it will be done after having a safe procedure. This convention, as well in relation to identity, is very important because one of its main principles is the principle of subsidiarity. This is that we need to do our utmost in order to support birth families, in order that they can raise their children. Therefore, we are also keeping here identity. And if this is not possible, then we will try to find solutions, hopefully family solutions, permanent solution at domestic level. And if not, we will then go to intercountry. And if we go to an intercountry adoption and therefore the 93 Convention is applied, then again, very importantly, this convention tells us that we have to keep all the information. This is extremely important. And then as well, it has an article saying that it ensures the access to origins as long as it is permitted by the law of the state and in accordance with the appropriate guidance. So really here, again, we want to maintain the identity of the person having as well access to its previous identity, put it like that. And finally, a few words regarding the 1980 Child Abduction Convention. And this one as well, what is trying to help is children in keeping contact with both parents. And as it has been mentioned before, this is something that's very clear in the UN Convention on the Rights of the Child. How does it do that? Well, it tries to prevent the wrongful removal or retention abroad of children. And if this wrongful removal or retention has happened, then it will try to ensure the prompt return to the state of habitual residence of the child. And therefore, trying to keep contact with both parents, which is extremely important. And now I will turn to Philippe in order that he speaks about other ACCH conventions. Thank you.
Thanks a lot, Laura. Concerning the 1996 Child Protection Convention, as some of you know, this convention will assist with the recognition and enforcement across borders of measures of protections concerning children, including parental responsibility, custody rights, and access rights, thus helping children preserve their identity. Their relationship with their parent is part of their identity. The 96 Child Protection Convention will assist children in keeping contact with both parents, the same way as the 1980 Convention, thus, again, helping children to preserve their identity. The 96 Child Protection Conventions assist also with the placement abroad of children in foster family or the provision of care by kafala or analogous situations, taking into account the best interest of the child. This may assist establishing or re-establishing the identity of a child, where a child has been illegally deprived of some or all of the elements of their identity. Placement will provide a solution for these children in keeping their identity or re-establishing it. The 96 Child Protection Convention will assist with the protection of unaccompanied and separated children, as we saw recently in the case of Ukraine, and may assist with the location of their parents or other members of their family. Thus, again, helping children access and or to preserve their identity. One more point on the 96th Convention. The Convention allows for urgent or provisional measures of protection to be taken into the contracting party on the territory of which the children is present, where, for instance, they have been trafficked across borders. The Convention, therefore, not only gives effect to Article 35 of the UNCRC, which is to prevent trafficking of children, but also assist with the preservation of children's identity. And now I'll move to the 2007 Convention. The 2007 Child Support Convention establishes rules for the effective international recovery of child support and other forms of family maintenance. The Convention can assist with the establishment of parentage for the purpose of maintenance recovery, thus, again, helping children preserve their identity. Knowing who's your biological parent is part of the identity of a child. And the 2007 Child Support Convention may assist children in keeping contact with both parents, thus helping children preserve their identity. It's not sine qua non. It's not because you pay your child support that you have contact with your parent, with your child, sorry, but chances are that if you do, chances are that you maintain contact is higher than if you don't. So again, the Child Support Convention can assist in maintaining or preserving a child's identity. So this is what we wanted to say, and we thank you very much on behalf of Laura and myself for your attention, and wish you a nice webinar. Thanks a lot.
Thank you, Philippe, and thank you, Laura, for this excellent overview of the different conventions, which are super important given that there are so many children affected by these cross-border movements. I think what we'll try and do now is try Annie again from UNICEF, because I think his presentation should work this time. Yes, perfect, Annie, go for it.
Thank you, Mia, for confirming, and sincere apologies for the glitch earlier. I hope you continue to see the presentation. And I think it's really a good time to speak and reiterate what Dr. Todorova also mentioned and emphasized in terms of the Article 8. I can't see my presentation. Can you?
Yes.
Yeah, we can see it.
Okay.
We can see it perfectly.
Okay, that's good. Yeah, so just to reiterate the Article 8 in terms of supporting families, I think it's been very well established now in terms of the role and importance of family, because the CRC does recognize family unit as the fundamental to the growth and well-being of its members, and has primary responsibility for nurturing and protecting children. And the CRC also requires states to promote family care and establish comprehensive measures to support parents, families, and other caregivers in their child rearing responsibilities and prevent unnecessary separation and loss of family life and connections. And I think in that context, I would like to speak a little bit more about how the importance of family strengthening and the role of uh, supporting families to be able to better care for children also contributes to preserving uh, the child's right to identity. The 2009 guidelines on alternative care also highlight the range of measures that states must put in place to support families, address the drivers of child and family separation or abandonment, and direct resources and services towards providing family-based alternative care and preventing child institutionalization as well. We also heard references to the importance of ensuring that children's identity is preserved in any form of alternative care, including in residential care. Um, the 2019 resolution on the rights of the child is also a very, very critical milestone in the area of children without parental care as well as alternative care, because the resolution urges states to take effective action to provide support to families, prevent unnecessary separation of children from their parents, and provide a range of alternative care options for children who do not have family care. Uh, the resolution really was a very, very key moment, an unprecedented opportunity for all of us who are working on the care reform agenda globally. And it really sets forth the key things that need to be addressed and prioritized, because the resolution was quite unequivocal in terms of the importance of strengthening families and preventing separation. Uh, I just wanted to very quickly go over what are some of the UNICEF priorities in this area of work. And we have identified over the course of the time, based on the CRC, the CRPD, the general comments, as well as the 2019 UNGA resolution. These are the three key priorities for UNICEF in this area of work. Uh, Number one is strengthening families to prevent separation. The second priority is prioritize family-based alternative care for children who need alternative care. And the third priority is ending institutionalization of children. And these, as I mentioned, are really informed by the global movement on care reform, and where we are going, the solid evidence that we now have in terms of the harms of institutionalization, the harms of family separation, and so on and so forth. But what is really family strengthening? I think we need to spend a little bit more time on the focus on family strengthening here, because it's really a very, very multi-sectoral process of family strengthening. As you see here on the screen, there are a number of factors that play into what contributes to family strengthening, right from the economic security of the family in terms of availability of decent jobs, the availability of safety nets, including social protection programs for vulnerable families, including to address poverty, accessible and inclusive services in the community, such as health and education services, availability of inclusive and accessible daycare services, issues relating to food security, which are very often uh, key drivers of family separation. But we also have some really interesting solutions in terms of, for example, midday meals in schools that can contribute to strengthening food security, and housing and shelter are critical elements of family strengthening. And as you start digging deeper into these are really further exacerbated in many situations because of other cross-sectoral issues, such as disability, such as migration. The whole population of forcibly displaced persons, including refugees and migrants and IDPs, climate change, conflict, pandemics, as we have seen in the recent past, such as COVID-19, as well as gender, play a key role in terms of how these family strengthening measures can both be impacted but also be strengthened by, uh, uh, you know, by all these intersectionalities of what it really means to strengthen families on the ground. And what I'm going to speak about a little bit more is UNICEF's approach. So UNICEF has very clearly 5 priorities in terms of addressing the issue of prevention of family separation, as well as strengthening alternative care. One is to ensure a child and family strengthened response. All our actions must be focused on ensuring children's rights and children's right to uh, uh, care, protection, and protection from violence, abuse, and exploitation. The second is about creating an economy that values care. I think this is something that is still an emerging area of work, but really a core area of work going forward, especially given the unpaid labor that is involved in the economy of care, the labor of women, and the role of participant of women care workers, both informally and formally. It's something that we must address immediately. The third priority in UNICEF's approach is building caring systems and an effective workforce. We believe that a strong child protection system and a strong social service workforce are critical for strengthening care reform. Similarly, enhancing resources for family-based care in the community are critical, not just family-based care in the community, but inclusive and accessible care in the community much more broadly, but really also our ability to divert resources from traditional institutional care to more family based, community based care, and strengthening the data on children's care. So this is the broad approach that UNICEF follows. And now, if you allow me, I'm going to give a few examples of some of the work that we are doing. And I'll start by talking a little bit about Rwanda, where we have seen institutions to be really the magnets for charities, and where because of family poverty, because of inability to care, children are drawn into institutions, and more children were attracted to institutions. So working across Rwanda, sorry, with the government, um, the government managed to close a large number of institutions and residential facilities simultaneously and reduce the risk of children being placed into institutional cares. This also meant that running institution, you know, that those running institutions could not close in one district and set up institutions in another district. I think this is important so that uh, you know children just don't move from one institution into another, or from one district or one state into another state, because one state is closing institutions and another state is opening similar institutions. In Rwanda, we also saw a 2-year mass media campaign focused on the harms caused by institutional care and the benefits of children growing up in families. I think this is something that is very important, because the social and behavior change associated with the harms of institutional care are very often not focused on by the child protection sector, and that is something that has proven to be very effective in Rwanda. Uh, Closely monitoring the remaining institutional care, because it's true that while institutions are being closed, there continue to be some institutions, but the close monitoring of the institutional care facilities by social workers to ensure that they did not take in new children was equally important. So the focus really is about moving children from institutional care either to their own families or to family based alternative care, and not continue to have new children coming into residential care. Development of emergency foster care also offered in Rwanda as a very important alternative. Carers could take children at short notice and look after them whilst assessments were made about whether they could return to families or be placed for adoption or longer term foster care. 50 emergency foster cares were identified in Rwanda, and they were trained uh, for a period of time to make sure that they had all the necessary skills and support systems to provide emergency foster care. In Rwanda, social workers and psychologists also worked with teenage parents, which is also very important to address and offer counseling support services to young parents to try and avoid child abandonment. And the government of Rwanda is also supporting a campaign to prevent teenage pregnancy. So all of these factors, as you can see, are really a comprehensive strategy that needs to be established to support families, to strengthen families in different ways, by enhancing awareness about the harms of separation and institutional care, to supporting young parents to be able to take better care of children, and providing additional support to families is important. Very quickly about
But
Tajikistan.
Magdi, Annie,
Yeah,
maybe if you could just close up in a minute, just so that we leave some time for the young ladies who'd like to speak as well. Is that
sure.
okay? Thanks.
Yeah, sure. I will briefly speak about uh, Cambodia then, if that's okay.
Yep.
In Cambodia, yeah, Cambodia is an excellent example of how reform takes place through legislative processes, which were really accelerated in 2022. And a final draft of the child protection law was submitted to the government for their final review. The Ministry of Social Affairs, Youth and Rehabilitation have also endorsed in Cambodia the child protection standard operating procedures, which really govern the processes of separation of children, the placement of children, and so on and so forth. Uh, There is also an official proclamation endorsed in Cambodia that was endorsed by the ministry on the implementation of kinship and foster care, including guidelines on reintegration, transitioning, and closure of RCIs. This has really opened up space for expansion of family-based alternative care, which is equally important as we start talking about ending institutionalization. And alternative care in Somalia confirming that commitment of the country to the institutionalization of children is a top priority. The revised alternative care policy was also finalized, which is pending review in Cambodia. So this is a flavor of policy level work from Cambodia, and I'm sharing the presentation with our CHIP colleagues. So you can also look at examples from Tajikistan and Indonesia there. But Mia, I'll stop there.
Thanks for that, Annie. The work really in Cambodia and Rwanda is really phenomenal. It really has given children back their identity in terms of family relations. And without further ado, I'd like to warmly welcome Aurelia, Cadence, and Tegan from ATD Fourth World and Teen Advocacy to give their views on stolen identities, the devastating impact social work services has on the identity of children living in poverty in the UK. Thank you, ladies.
Thank you so much. Hello, everyone. My name is Cadence. Aurelia, Teague, and I are part of the Youth Voices Project, which is a project where we have been speaking to young people who have experienced poverty and have been impacted by social services. We have put their views together for a submission to the Social, Cultural, Economic Rights Committee, which is doing a review of the UK. Our first submission was sent to them in December last year, and we are working on our second submission, which is due next year. We are going to talk about the impact the care system has on a child's identity, but I first wanted to talk about why in particular we are looking at young people who have been impacted by poverty. We know that if you are in poverty, you are much more likely to be removed from your family. They call it negligence because maybe you went to school in dirty clothes. What everyone sees is a mother who didn't wash them. What they don't see is that the mother hand washed their clothes because the washing machine broke and they can't afford to buy a new one. Instead, she made sure there was dinner for the next month. Poverty is not negligence from a family. It is negligence by the state refusing to support and help families, which they then punish by tearing the families apart, saying it is for their own good. Anyone who loved that child is forgotten and condemned. It is known and recognized that a child removed is a child broken. But it's not just one child. It's a broken family. They will grieve for a child that has not died, and if they survive, they will never stop hurting for them. They will never stop hoping for them, and they will never forget that piece of their heart.
When we ask ourselves, who am I, we often relate that to other people. I'm a sister, I'm a carer, I'm a daughter, I'm a friend. When children are stolen, we don't just take their family and friends from them, we take themselves away from them. I am not me without these pieces of my identity. I am not me if I'm not a sister or carer or a friend. The cruelty of leaving a child with nothing but a hollow shell of who they were is indescribable. The damage this does and the trauma it inflicts is irreversible and something that stays with you forever. A social worker will take your family, they will take your home, and they will take away your love. But a social worker will take even yourself from you. There is nothing not stolen when a child is taken away. Something so often overlooked is siblings. We know a child's mother is important, we even know a child's grandfather is important, but siblings are often cast aside and pushed away because we are children too, and that means we don't matter, it means we don't count, and it means that we don't get to be proper people. My siblings are some of the most important people in the world to me, and yet no one cares what I have to say about them, and no one cares what they have to say about me, because siblings don't matter in the real world, not to anyone but each other. But no one will listen to us. Siblings are pushed and separated and broken because an adult has made a mistake, because something went wrong. No one cares that it's not our fault, and no one looks out for them. Siblings should never be separated, not unless they're hurting each other. I do not believe the current system cares about the best interest of the child, because siblings are still separated, and that's not okay. It's not our fault that all of the adults can't get along.
Thank you. Hello, I'm Tegan, a 21-year-old adoptee who was adopted at the age of 4 after 2 years in care. There have been many positives of my story, including the gain of identity through my journey and even losing parts that I'm honestly quite happy I have. However, parts of my identity that I wish I still had, and parts in some ways that I've had to fight to keep or be accepted by others. This has been challenging for me and doesn't feel fair in most cases, as yes, they have been stolen. The first is the fact I am a sibling, have been my entire life, but by most perspectives or under the eyes of the law, I grew up as I am not, at least in the same capacity as when I was with my birth family. I grew up as an only child, which suited me. However, I was always very conscious of I wasn't an only child. It frustrated me when people called me an only child, as felt my sisters were being ignored or my role as a sibling was also being ignored. I grew to accept it to some degree, but never fully. When I can, I distinguish that I grew up as an only child to show that difference. I've always heard people talk about middle children for jokes and such. I've always listened but thought they're not relevant to me. However, it recently dawned upon me I am a middle child. This shouldn't be the case. This should have been an identity I know about as soon as my younger sisters were born. I hope to build some connection and relationship with my sisters over time. However, I know it won't be the same as if we had grown up together. We've all been through our own challenges as well as lived our own lives. I will never truly be their sister, and will never truly have that sister identity, especially to others. The other way is my Irish heritage. I have been super lucky that my adoptive parents have always been supportive that I have Irish heritage, promoting that fact wherever possible, and felt right. They did this from the beginning, despite people telling them that they didn't have to. I remember the census in 2011, but my mum was asked what I wanted to be put down as my ethnicity. This was great, but my adoptive parents are only one part of my life. I had my birthright to Irish citizenship taken away from me as soon as I was adopted. Others associate me with my adoptive parents' heritage, just assuming I'm the same. I get disbelief about the fact I am different or Irish. I honestly still sometimes question if it is right to say I am Irish. That isn't right. I should always feel proud of a fact, not feeling like I'm faking it. As much as my mum's offered to support my understanding, it would have been extra work, so barely know anything about Ireland or the culture. Even though slowly learning about it, it's sad. Thank you for listening to our testimonies. We are just a few of many young people's voices. I'm only giving you a few examples of how a person's identity can be stolen from the young people. We know this from those that we have spoken to as peer researchers. So take what we have said, but also listen to others.
Thank you, Cadence, Aurelia, and Tegan. Very powerful words. I just have one question for you. In just one or two sentences, if you had a wish for states, what do you think, or what would you recommend that they do to ensure that your identities are not stolen? And I'll also give that question also to Velina, if she had two main recommendations to states, also to Laura and Philip, and also to Annie, and we'll do it in that order. So we start with you, Tegan, and then Cadence and Aurelia. Thank you.
Thank you. I think the key thought in this question is why do they need to be restored in the first place? Shouldn't we be working towards a system where identities are always there, not stolen? I get though that's not always possible, but it should be an aim. The state could make it easier to restore these identities, like giving certain legal statuses back, supporting people to have time with their family in ways that is right for them, including less formal meetings and putting it as a priority, not just an if thing, and making sure there is the right support for people, from helping them understand what they've been through to knowing their rights. Finally, make sure to listen to the voices of those with lived experience and take on board what's said.
Thanks for that, Tegan. Cadence, Aurelia, what would you like to tell governments or ask states?
I think in order to stop identity from being broken, we need to stop removing children from their families, because that will destroy their identities and take away everything that's important to them. And so we need to just stop taking children away from their families. But in cases where children have already been removed or have to be removed because there is simply no other option, however, wherever possible, other options should be looked into. I think what needs to happen is professionals need to work with children, and they need to listen to children to say who is important in your life, who are the relationships that are important to you, what are the connections that are important to you. And then while they're in care, they need to be supported to keep those connections and relationships with their siblings, with their favorite teacher, with their dog, whoever is important to them, whatever makes them feel like them, they need to be supported to continue having that relationship.
Thank you for that, ladies. I move now to Velina. And what would you seeing as many states that you examine, what would be your 1 or 2 recommendations for all states?
Thank you, Mia. Thank you to the previous speakers. Very interesting. I will recommend the following. Collect data about child's biological or genetic origin. Collect and store and keep. Ensure access of children in appropriate age and inform children about their right to identity and access to information, and provide appropriate services, consultancy, support to the child and to the family.
Thanks for that, Belina. Thanks for that. And also now, Philip and Laura, if you could make some recommendations to states, what would they be?
Yes, certainly, Mia. Thanks a lot. Well, look, I have 2 thoughts in mind. I don't know if the 2 thoughts are for me and Laura. She may have 2 thoughts as well. Immediately, it's from the perspective of the Hague Conference, to become parties to the conventions. Absolutely. This is the first priority. I would actually move forward. The second one is, when you become party, implement them properly. Yeah, and then there are other steps after that. And I leave the floor to Laura for that.
Thanks, Philippe. Laura?
Thank you very much. I fully agree with Philippe, and maybe just an example taking from what has just said before. I think on the one side, implementing the principle of subsidiarity that has been explained very well by many in the minutes that we are here. So I think we should keep that. And this is very clearly in the 93 Adoption Convention, that we can keep it. And then as well, agreeing with Belina with the importance of collecting and preserving information for identity is clear. At least let's do that. Then access can be more difficult depending on the country where you are, but if at least you already have the information, you can decide later on what's going to happen. And that access, of course, it should be always under appropriate guidance. That makes a difference. It really makes a difference if you have support and counseling and information that can really make a change on how you can absorb personally that information. Thank you.
Thanks for that, Laura. And now, Annie, turning to you to have the final word for this first round before we have a 5-minute pause. What would you recommend to states, having worked in so many countries, for UNICEF? Oh, maybe I think Annie's left us. He's gone, but that's okay. But thank you for this excellent first session. It's very rich in information. And some good key takeaways. The PowerPoints will be uploaded onto our website so that people can have a look at those. And given that we're actually finishing 2 minutes before 2, we will start the next session at 2:03, according to Swiss timing. But thank you for our excellent first round of speakers, and especially to the young ladies for taking the time to share your lived experience. Very powerful. And we hope that states will listen to you and will take on board the importance of keeping siblings together and taking into account what is important to you in terms of connections and relationships. Thank you for that. Have a good break, and we'll be back at 2:03.
Falsified or not preserved, states have a clear obligation to speedily restore the elements in questions, whilst also preserving and protecting the privacy of any child victims of identity. There are still many obstacles to this, because sometimes many years have passed between the event itself and the discovery of these missing elements or falsified elements, that CRVS systems are still poorly resourced or not set up to record information about the whole of the child's identity. And there are, however, some promising practices in this regard. Maybe we can go back to it at the end of the session. At the moment, this publication is available in English, French, and Spanish on our website. Please have a look at it. We very much look forward to any feedback or any information you wish to share about it. The next steps for us are obviously to research, advocate, and provide technical assistance on specific issues relating to the child's identity. And we are also in the process of drafting at the moment, preparing regional publications, so regional perspectives to this signature publication. Thank you very much.
Thanks, Christina, for that super succinct presentation of a publication that's like over 150 pages. So we'll ask you some questions maybe at the end of this session, but now I'd like to give the floor to Professor Marilyn Freeman and Professor Nicola Taylor. A special thanks to Nikki because it's past midnight in New Zealand for her. But thank you, ladies, for your presentation on identity and child participation rights in family law proceedings.
Thank you very much for the invitation, Mia, and welcome to all other participants. We're going to be talking about identity and child participation in the context of family law proceedings, and I'm going to be starting off by talking about both participation and then identity, and Marilyn will then take over and look at these issues in the context of family law proceedings. So we just want to make the obvious point at the beginning that our topic is really addressing the intersection between a number of UNCRC rights, and a number of these have already been talked about in this webinar already. So clearly our main focus has been on Article 8 and on Article 12 around children's right to express their views. But we just wanted to make the obvious point at the beginning that there's a number of other articles that have extreme importance here. 9.3, Article 13 on freedom of expression, 14, 15, and particularly Article 17 around the access to information for a child, because without information, it's very difficult for a child to be able to express their views in a holistic and meaningful way. So turning to what is participation, we just note at the outset that defining this concept is not straightforward. It's not actually referred to directly as that phrase in the UNCRC. And so it's important to turn to the general comment number 12 in relation to consideration about what is meant by participation in this international context. And I guess in this way, thinking about how the term has evolved over time and is now widely used to describe ongoing processes. So it's not a one-off opportunity, it's an ongoing experience that children should be having the opportunity to avail themselves of, including information sharing, dialogue, mutual respect, and looking at how children can learn how their views and those of adults can be taken into account to shape the outcome of processes like those in the courts and legal processes. Participation, as we all know too, is a fundamental human right, and we just have a quote here from Garrison Lansdowne about the importance of all people having the right to express their views when decisions are being made that directly affect their lives, and that children are people too, so it's important to also be providing that opportunity to them, whether it's an individual decision in relation to their personal circumstances, like their parents' divorce or separation, or broader issues. So children having the right to articulate their concerns and participate in the development of policy and decision-making needs to be taken very seriously. And I think the courts and lawyers do that in many respects. Looking at identity, and obviously you'll all be very familiar with this concept, but we just want to point out the constellation of historical and evolving characteristics that comprise how identity is formed, maintained, and at times restored. So there's internal aspects to identity formation, the individual unique characteristics and perceptions of the person themselves, and then also how identity is shaped externally by social and cultural context. Often, at the beginning, that's within the context of the family and the local community, but later as the child grows and becomes an adolescent and then later an adult, then obviously it's peers and other adults that influence that identity very strongly. So collectively, these internal and external characteristics provide children with the understanding understanding of where they have come from, who they are, and the right to decide who they will become. So we just want to really identify tonight how important it is to consider identity as a dynamic concept. It's this idea of reciprocity and evolving experience and relationships, which include change and transitions and the adaptation to those circumstances. And also just to highlight the importance of the sense of belonging that underpins a strong identity and having worth and respect for who we are as people. So another important concept we want to emphasize today is the importance of children as co-constructors of their own identity. And this is really speaking to what we know about, for example, sociocultural theory and childhood studies in relation to children as having agency. So we think it's important that this notion of children as being agentic and co-constructing their own identity is a really critical concept to be considering in relation to the importance of participation. So children in the research evidence that we reviewed that had positive identities were certainly much more involved in decisions about their own lives and in the construction of their own identity. And that's a possible way forward that we can help promote that in other areas around identity formation and restoration. Marilyn.
Yes, thank you. And hello to everybody from me. So what are family law proceedings? May sound a deceptively easy question, but we thought there was rather more to it that we wanted to look at. So certainly family law proceedings now extend to what we used to call alternative dispute resolution processes. We don't refer to it quite so often that way now because they play such an important role in these cases. So out of court dispute resolution processes, in court dispute resolution processes. But sorry, Nikki, can we just go back to that one? Thanks. But is family law proceedings as a concept, is that limited to the topics that we traditionally teach and learn as part of family law courses? Is family law limited by construction in this way? Or is family law, and thus family law proceedings, a sufficiently flexible term to include all issues relating to children and therefore families? That was the sort of thinking process that we embarked upon. And we decided to do some more thinking and explore those thoughts further. So we go on to the next slide and look at why. Because we think there are important synergies between those historically unconnected areas of international law regarding the impact of those events and those proceedings on the identity of the children involved in them. So when we talk about traditional categories of family law, we talk about things like custody proceedings and perhaps care and protection proceedings. But what about these less traditional categories, the categories of international law that do relate to children and families, but haven't historically been considered as part of family law? And you can see at the bottom of this slide a reference to a book which is coming out of those thoughts that we had, looking at children and young people's identities in international law, life events law, and selfhood. And I'm delighted to say that Mia Danbach is writing the foreword to the book for us, and some of those who are present here today are contributing to that book. So we're very excited about where this might lead to, because some of those, if we say non-traditional areas, are things like child detention, unaccompanied minor children, gender, child soldiers. And looking at those together with more traditional family law areas like forced marriage, child bride, care and protection of children, along with our international colleagues, specialist colleagues in these areas, is a very exciting project and a very instructive way, I think, of bringing together the issue of identity, which permeates through what we would argue are family law proceedings, even if not recognized as such historically. So that's something that we're working on now. But why is it important? If we go on to the next slide, we can have a look at why. So what are the links between identity and participation in family law proceedings? Well, as Nick has already highlighted, identity is both an internal and an external concept. So it's also the result of how other people define the child, how he or she is understood or not understood, and shown respect or not shown respect, and how social experiences serve as a mirror for their identities. And also, there is a role played by parents, and we would argue by professionals too, courts included, in assuring a child's positive identity and helping them respond to new and sometimes challenging situations. So on to the next slide. So again, something that Nick has alluded to, children's role as co-constructors in defining their identity is more likely to flourish when they can participate. That doesn't sit so easily with certain traditional ideas of childhood, where children were typically, less so, but not entirely differently now, where they were typically relegated to the shadows. That a child's cultural, religious, family identity should not be exclusively defined by adults. Children must have a voice in this process, and that voice must be consistent with that other UNCRC rights, which we looked at earlier in this PowerPoint, back on number 2, slide number 2. So there is an interaction between these UNCRC rights. There are some which are, hit you in the face, that are very obvious, and some where you have to look for the interaction. But undoubtedly, adults will influence a child's identity. And we've included a quote here from Tobin and Todres about the UNCRC anticipating and requiring that children play an active role in the construction and discovery of their own identity, consistent with their evolving capacities. So next slide, please. And we just want to finish with why? Why are these opportunities in family law proceedings, however you define those, and we define them widely, why they are important for a child's identity? And it's we left you with a very simple quote, but really, I think, impactful, because these are important, because these are significant decisions, and they impact a child's safety often, a child's well-being almost always, a child's identity and belonging. And that's why it's important. That's why it's important that children have opportunities to participate, and that's why it's important to consider what family law proceedings mean and whether they are flexible enough, and we argue that they are, to take them outside of what has historically been understood to constitute family law proceedings. So we leave you with that to consider. Thank you.
Thank you for that, Nikki and Marilyn, and very instructive presentation on a broad view of what family law is. I really look forward to reading the different chapters in this forthcoming book. And without further ado, if I can introduce everybody to Dr. Katarina Trimmings from the University of Aberdeen, who will talk to us about child identity in the context of parental child abduction. So building on what Philip and Laura has presented earlier. Thank Thank you, Katerina.
Thank you, Mia. Good afternoon, everyone. So I'll be talking about child identity in the context of parental child abduction. A parental child abduction can take two forms. A removal of the child from the state of his or her habitual residence in breach of the custody rights of the left behind parent, and second, a retention of a child outside of the state of his or her habitual residence beyond the period of time that had been authorized by the left behind parent. Now, the key international instrument providing for a regulation of parental child abduction is the 1988 Child Abduction Convention. Under this convention, where a child is wrongfully removed or retained and less than 12 months have elapsed before the start of the written proceedings, the child is to be returned immediately to the country of his or her habitual residence. Even if more than 12 months have passed, the child should still be returned unless it is shown that the child is now settled in his or her new environment. So the expectation is that the child should be returned unless one of the limited exceptions to return applies. Now, the underlying philosophy of the convention could be summarized as follows. First, except in exceptional circumstances, the wrongful removal or retention of a child across borders is not in the best interest of the child. Second, the principle of prompt return should serve as a deterrent to possible future child abductions. And this is seen by the convention as being in the interest of children generally. And third, the return of the child to the state of his or her habitual residence should promote the child's interest by asserting or supporting the child's right to have contact with both parents. How? By supporting continuity in the child's life and by ensuring that any decisions related to custody and access are made by the most appropriate jurisdiction, having regard to the likely availability of relevant evidence. So as we can see, at least one of these points clearly has a link with the preservation of a child's right to identity. By supporting the right of the child to have contact with both parents and supporting continuity in the child's life, the 1980 Convention seeks to preserve family relations, culture, language, and so on. Despite that, generally, the problem of preservation of child's identity in child abduction cases has received very little attention. So in this brief presentation, I will first set out the relevant elements of identity. Then I will consider in what circumstances identity issues may arise in child abduction cases. And finally, I will outline a few recommendations that have been made to preserve and restore child's identity in cases of parental child abduction. So, what elements of identity are at stake in situations involving parental child abduction, and which provisions of the UNCRC come into play here? Well, in these situations, the preservation of a child's right to identity, including nationality, name, and family relations, is guaranteed by Article 8.1, is at stake. In particular, the family relations aspect of identity is at risk of being lost in situations where the child is taken across borders and loses contact with the left behind parent and possibly extended family. And this also has implications for the right of the child to know and be cared for by his or her parents, as guaranteed by Article 7.1. The state also has specific obligations when a child is separated from one of his parents to ensure that the child maintains personal relations and direct contact with both parents on a regular basis, obviously except if it is contrary to the child's best interests. So where do the identity issues arise in child abduction cases? Now, back in the 1990s, social science scholars started addressing identity-related concerns for children wrongfully removed or retained by their parents. These scholars, however, took a rather narrow view on the matter, as can be seen from the text quoted on the screen. So you can see the most pervasive scenario is that the abducting parent goes into hiding. And these kidnappings are very cleverly plotted and planned. The target parent has no boarding address or telephone numbers. So these scholars focused on a possible concealment of the child by the abducting parent, recognizing that such actions of the abducting parent were likely to affect the relationship between the child and the left-behind parent. And around the time, the term parental alienation was coined to describe the potential negative impact on the child victim. The problem of preservation of child identity in child abduction cases is, however, much more complex than that. And although a concealment of the child by the abducting parent is indeed one of the situations when identity-related concerns evidently arise, identity issues may arise also at a later stage after the return proceedings until the 1918 conventions have been concluded. And this can occur both in cases when the child is returned to the state of his or her habitual residence, and in cases where the court does not order the child's return. So I will now address these three situations separately. So the first situation, well, it is not uncommon in cases of parent-to-child abduction for the abducting parent to indeed change the identity of the child, including the child's name, and go into hiding. And research has found that abducting parents sometimes change their names, their children's names, identities, and appearances, with the children then having to lie, for example, at school, about their reasons for being unable to provide proper records or having to provide records that have been falsified. And effectively, such abducting parent sentences himself or herself and the child to the life of a fugitive. So unsurprisingly, such children often suffer from an identity crisis. And should the abducting parent and the child be apprehended, the abducting parent is likely to resist a possible return application on the ground of Article 12.2, meaning that the child is now settled in the new environment. And this is the case in particular if an extended period of time has passed since the abduction. And in determining whether the child has indeed settled in the new environment, the judge may consider if the child was interacting with family members, attending school, whether he or she has formed friendships or as part of any social group. So these factors are then relevant for the child's new identity because of the newly formed family and social relations, which would be disturbed if the child was returned to his or her state of habitual residence. So a return order made in such circumstances would be likely to again uproot the child and therefore replicate the harmful effects of the initial child abduction. Now, a situation where the court ordered not to return the child to the state of his or her habitual residence is made. So where an exception to return has been established and the return application has been rejected, there is a risk that the child will lose contact with his or her or with the left-behind parent, and by extension, his or her extended family and culture. And even if a contact order in favor of the left-behind parent is made in subsequent substantive proceedings, there is no guarantee that the contact arrangements will be adhered to by the abducting parent. Indeed, contact orders, in particular those issued in the cross-border context, are notoriously difficult to enforce. And now the third situation where a court order to return the child to the state of his or her habitual residence has been made. So parental child abduction may be problematic from the perspective of preserving the child's identity, even in these sort of situations. Because in order or in the attempt to restore the status quo ante, there is a risk that the child will lose contact with the taking parent, and by extension, his or her extended family and culture. Now imagine a scenario, and this one is based on a real case, although I have changed some of the facts. So a situation involving an Australian mother who has fled Italy with her 1-year-old daughter. The child has been ordered to return to Italy by the Australian courts. In the meantime, the father obtained a provisional custody order in Italy, entrusting him with a sole custody of the child. Immediately upon the mother and the child's return to Italy, the child is removed from the mother's care by the police and placed into physical care of the father. In subsequent custody and contact proceedings, the provisional custodial arrangements are confirmed, and the mother is granted only supervised access to the child of 3 hours per month. And the mother does not speak Italian, and the father and his extended family have no intention of teaching the child to speak English, so as to preserve that part of her identity. In fact, it is their deliberate intention to erase that part of the child's identity. So this, combined with the meager contact arrangements with her mother, make it very difficult, if not impossible, for the child to preserve her full identity. So another possible scenario is that the taking parent is
Katerina,
unable,
Katerina, if I could ask you just to
wrap it up. Okay, yeah, I'm nearly finished, and I will then address the recommendations perhaps
in the second question.
Yeah.
Perfect.
Okay, so just this last point about another possible scenario where the taking parent may be unable or unwilling to return with the child to the state of habitual residence due to, for example, immigration issues or the fact that criminal proceedings have been initiated against them in the state of habitual residence. And also where the abduction is motivated by domestic abuse, the taking parent may be unable to return due to safety concerns. So in both situations, the child's right to preserve his own identity will be at risk. So I will stop here. Thank you, Mia, for reminding me.
Thanks, Katerina. We can really see that identity issues are at the center of child abduction proceedings, either way, whether the child is returned or whether the child is able to stay in the other country, the child's identity will be affected by these situations. What I'd like to do now is to welcome Arthur and Audrey from the Association Origins, who will explain to us some of the new developments with the new bioethics law. Thank you, Arthur and Audrey. You can start. We can see your presentation, but we can't hear you. Okay, now we can hear you.
Thank you, Mia. So who are we? Arthur is a donor conceived person. He always knew it. It wasn't a secret. In 2006, he started to testify publicly of his need to know who is the donor. And in 2017, through a DNA test, but on a website, he found his donor in 11 hours. Gerard, the donor, lives only 150 kilometers from us.
Audrey Kirmalvezen, she chose to specialize as lawyer in bioethical law, and she discovered 6 years later, in 2009, that she had been conceived by a donor. She was 29 years old. She asked the French hospital if she has the same donor as her brother and as her fiancé, me, if her donor is dead, and if he's still alive, that this question could be asked to him. Do you want to stay anonymous, or would you like to give some piece of information, such as a photo of you or your medical history? Everything was denied. She lost each trial. She filed a request to European Court of Human Rights in 2016, and her request is close to being judged, probably in the second semester of 2020. 23.
We founded the Origin Association, which is an association of donor conceived people, donor and parents. And that helps everyone searching for his origins and try to convince the politician and the public of the need to change the law.
The new French bioethical law, what changes for who?
So for donor, there was effective changes from 1st September 2022. For parents, assisted reproduction by donor was opened to women in couple and to single women. And there's now a legal recommendation for each parent to tell the truth to his child about donor conception.
For donor conceived people, for the moment, very few changes.
Since 1st September 2022, for gamete or embryo donation, you have to leave your identity and to file out a legal form which contain non-identifying data. And all this information, identity and non-identifying data, will be automatically transmitted to the child from 18-year-old if he asks for it.
Problem, all the gametes and embryos donated since 1st September 22 are unused. French doctors should primarily use gametes and embryo donated before 1st September 2022. For every child conceived by donor today, there is no right to, no guarantee to access to information, even non-identifying data, without donor consent. These children will only find out at the last moment when they will be 18 years old, if yes or no, their donor agrees to give information. 3 situations are possible.
First situation, the donor consent to give his identity. So there's no problem except 3. 18-year-old, it's very late to have access to that kind of fundamental information. And children will never know donor's medical history. For this, the child has to ask the donor because it's not in the file of non-identifying data. And in all cases, donor conceived child will never have any information about his siblings. That means with people conceived by the same donor.
Second situation, the donor refuses to give his identity and accepts to give only non-identifying data. The donor should fill a legal form which is not satisfactory. For example, it contains absolutely no medical information about the donor, except minimum information that is completely useless. What was your general physical condition? Can you rate your state of mental health when you donated your gamete? The donor can explain why he put a 10 or a 2, for example. How often do you practice physical activity or sport when you donated your gametes? Without being able to tell, for example, what kind of sport is being undertaken.
For example, the donor can say, I was in a good condition, but he can't say why. Or if he was in a bad condition, he can't say anything. The legal form contains nothing about the donor's personality or anything that could help to imagine or represent him. There is, for example, a physical description, but for example, for skin color, you have to choose between very light skin or very pale skin or dark skin or very dark skin. Instead of having, for example, Asiatic type, African type, European type. And it's the same for donor's motivation. The donor can write a short text to express his motivation for being a donor, but if he puts anything that could be identifying, the doctor can tell him to delete the sentences. And more, the donor can avoid writing a test and can just check boxes like I'm a donor because I want to help someone to become a parent. I'm a sperm donor because I'm a blood donor, etc.
Third situation, the donor is not localizable. The donor refuses to give any information, even non-identifying. The donor is dead. Children can't have access to any information, neither donor's identity nor non-identifying data, like the reason of his death, for example.
Can France be condemned by a European Court of Human Rights? I think so, because the new law doesn't change anything, for example, to me. French administration sent me a letter in March 2023 to tell me that my donor is dead, 14 years old after my first application. And they added that they can't give me any information, even non-identifying data, because the donor didn't consent before dying. So I can't know without making an illegal DNA test if my brother and I've been conceived by the same donor, if my husband and I have been conceived by the same donor, if I have siblings in nature and how many or who they are, and the medical history of my donor while it's still in this file in the French hospital. Second reason.
The French legislation is not a fair balance between the different parties involved. Compared secret childbirth, accouchement sous X, the children born under X can have access to non-identifying data about his or her biological parents and biological siblings without biological parents' consent in his adoption file. Donor conceived people, no adoption file and no file at all. If the biological mother dies before the administration asks her if she wants to stay anonymous or not, her identity is transmitted to the child automatically.
Third reason, for donors before 1st September 2022, the French legislator chose to limit the access to donor's identity only if donor consent when he will be asked for. But this condition wasn't justified concerning donor before the first bioethical law in France. That means the law of 29 July 1994, because there were no legal anonymity, and this condition wasn't necessary about other donors, because the French principle of anonymity is only between the donor and the recipient, and it doesn't concern the child who is completely forgotten.
What is the dream bioethical law? No? Okay.
No.
Okay.
No,
Thank you. Okay, the dream bioethics law will maybe listen to actually now, because then I will ask everybody that presented in this panel, what would be your dream recommendation for states to take into account? And so we can start with you, Arthur and Audrey. What would be your dream bioethics law?
Okay.
And also for Marilyn and Nicola, what would you think would be the dream family law practice? For Katerina, what would be the dream way to deal with abduction matters? And for Christina, maybe a few recommendations from the publication, but just briefly, like 1 or 2 minutes before we have a pause. Thank you.
Okay.
Je lis la slide? Okay. Si, yeah? Okay. What is the dream bioethical laws? Legalization of DNA testing, ancestry ones, create an anonymous exchange platform between donors and donor conceived people that permit discovering each other step-by-step updates to medical data in real time, and contacting all the past donors to ask them if they accept the new condition to accelerate the creation of the new gamete stock.
Transmission to parents, non-identifying data about donors, for example, medical history of the donor from the birth of their child. Transmission to donor, the number and the gender of children conceived by their donation. And transmission to donor conceived people, donor's medical history, and information about siblings.
Thank you for that. I hope that the French authorities will listen and have some sense in terms of this bioethics law. And if not, the Committee on the Rights of the Child can make some strong recommendations on how to improve this law so that it's aligned with the Convention on the Rights of the Child. Marilyn and Nicola, do you have some last words to say?
Sure. I think from my perspective, in relation to family law proceedings, my dream would be to have well-trained and sensitive family justice professionals, whether that's lawyers, judges, social workers, psychologists, the whole range of people that end up working with children mediators too, who are able to understand the important role that they play in scaffolding children's emerging understanding about their family circumstances and offer them the opportunities to participate in those decision-making processes that are very much about their well-being and welfare and best interests going forward. Marilyn, over to you.
Okay, if we're dreaming, I have a big dream. I would urge states who are considering family law decisions in children's cases to also consider the obligation in Article 9.3 at the same time about how best to honour the requirement to maintain personal relations and direct contact with both parents. And here's the dream, that there would be some monitoring of those decisions that could take place so that the effect of those decisions and the impact on the children concerned could be evaluated. That has resource implications, I realise, but I'm dreaming. So that's what I think we need, some aftercare and support for these decisions.
Thanks for that, Marilyn. It's good to dream. We have to keep dreaming. And Katerina?
Thank you, Mia. So just a few points, basically what I had on the last slide when I ran out of time. So I think in the first instance, the way to preserve child's identity in child abduction, well, is to prevent child abductions from happening in the first instance, and perhaps trying to encourage agreed mediated solutions, international family relocation, instead of sort of letting parents to abduct their children. But obviously that's not always possible. So when it comes to return proceedings happening, a court should take identity issues seriously when deciding whether to return a child or not. Perhaps under Article 13.2, listening to children, because children may express strong preferences, placing values on having meaningful contact with one parent, or practicing certain religion, or taking part in certain cultural activities. So I think these are important issues that courts should take into account. Sometimes perhaps they do, sometimes maybe less so. Also, upon the decision on return or non-return, I think efforts should be made to facilitate contact with the other parent and extended family members, including using technology, but obviously contact orders are difficult to enforce, especially in the cross-border context. So again, I think mediated solutions may be helpful, although these are sort of high conflict situations where mediation may not work. So I think it is very difficult, but perhaps really just trying to prevent these high conflict situations from escalating in the present.
Okay, thanks, Katerina. Very wise. It's often prevention is often the best solution. And Christina, just last words for you before we have our next pause before the third session.
Yes, thank you, Mia. Yes, really from child identity protection, I mean, we have lots of examples of countries which still have obstacles, but also many promising practices, which I think we managed to share in our publication. And I really want to draw your attention to the last bit, to the restoration of identity. I think we have examples there in many countries that can maybe not make us dream, but at least inspire us for future dreams. In particular, decisions in regional human rights mechanisms in the Americas in relation to identity and adoptees in Guatemala, collective lawsuits in Chile, obviously national apologies in Australia and Canada in relation to children in care, who were forced into care, a national commission for the right to identity in Argentina, inquiries and commissions in several countries in Europe, in Switzerland, Netherlands, Belgium. So I think we have some examples of steps forward in restoring children's identity. So please have a look at our publication for further examples.
Okay. Thanks for that, Christine. And thank you to all our panelists for this last session. I found it very convincing as we dove into topics now, and we really can see that this issue of identity is very central to many of the issues that children are facing. We'll now have a short pause because we have 5 speakers instead of just 4 for the next and last session, and which again we're going now from very international high level, and we're going to go, then we've gone into topics, and now we're going to go into regions. So if we could start again in 3 minutes, I think everyone can have their coffee quickly or just have it while we're watching, and we'll start again at 3:02. Thank you for everyone. So now we find ourselves at the third and final session that we have today. And I'm pleased to introduce to you Professor Elizabeth Pangalangan from the University of the Philippines, who has extensive experience in the region. Thank you, Elizabeth. I give the floor to you.
Thank you. I'm trying to share my screen. But it works.
Yep, it's perfect. We can see it. We just need you to maybe open the PowerPoint at the bottom so it's full screen, and then it should be better.
Does this work? Okay.
Yeah.
So good evening. Thank you for inviting me to this forum. I'm speaking on the child's right to identity in family relations from an Asia-Pacific perspective. This is rather broad, and so for a 10-minute presentation, I had to choose where to focus on. But what I can say is that family law is one of the more difficult and challenging areas to discuss in either a human rights perspective or a private international law perspective. It is an area of substantive law that inexorably reflects state policies often moored to fundamental beliefs and societal values. So our family laws are often reflective of very closely held values of a given society. Therefore, the acceptance of surrogacy as a means of forming a family remains a contested site in the Asian region. And it is particularly challenging in cross-border legal parentage cases, including international surrogacy arrangements. Now, sorry, I do this. Okay, so in the Hague Conference on Private International Law 2011 report, and Philip and Laura spoke about the efforts of the HCCH in this regard. But in their report, they pointed out that there are scientific developments such as artificial insemination and IVF, which have made surrogacy a realistic option. Likewise, there has been an increasing acceptance in some states of parenting within alternative family forms. Third, there are different legal approaches to surrogacy. So some states are quite liberal and others are restrictive. And fourth, cross-border surrogacy likely involve lower costs or fewer perceived risks and the ready availability of poor surrogates. These are among the reasons for surrogacy being top of mind or a burning issue for many countries. Now, how have countries in Asia dealt with the problem of surrogacy or the issue of surrogacy. First, there's a group of countries which impose a blanket prohibition on all forms of surrogacy, either by national law or by rules and ethical guidelines. A second group would allow or disallow surrogacy based on whether or not it is altruistic. So you will notice in my presentation in a while that there is a trend towards accepting altruistic but banning commercial surrogacy. Likewise, we have countries which allow or disallow surrogacy based on the party's circumstances, such as their religion or nationality, or without passing any specific law on surrogacy, allow or disallow it depending on general laws on contract, family law, or even criminal law. And third, alternative to address surrogacy in Asia is to allow surrogacy, leaving the matter wholly to private ordering. And we will see if any of the states actually have allowed this. Now, for those which expressly ban surrogacy, I was able to find Macau in their civil code says that any agreement to give birth or pregnancy to a third person is void. So this is an express ban on surrogacy that we can find in national laws or in a national law, their civil code. There are other countries which expressly ban commercial surrogacy through national laws. So you see national laws that will be applicable everywhere in their territory, but the ban is on commercial surrogacy. And we see this in South Korea, Hong Kong, Thailand, and India. In Hong Kong, for instance, surrogacy is recognized as legal in Hong Kong for as long as it complies with the requisites in the Human Reproductive Technology Ordinance. The ordinance says that the contract, surrogacy contract, must be made before the surrogate becomes pregnant, and that the pregnancy should be the result of ART, not sexual intercourse. It requires the delivery of the child to the other contracting party and the transfer of the biological mother's legal parental rights. Part 3 of the same law expressly prohibits commercial surrogacy. Some other countries ban surrogacy, but not through national laws, but merely through rules and guidelines. So you have countries such as China, Indonesia, Cambodia, and Taiwan that regulate surrogacy, whether commercial or altruistic, through other means such as administrative regulations by the Ministry of Health or the Ministry of Justice. But these administrative regulations directly deal with surrogacy. Some other countries, on the other hand, regulate surrogacy through ethical guidelines, such as Singapore, through assisted reproduction centers. So that's what they regulate. Or the Japanese Society of OBGYN guidelines for physicians performing surrogacy. Likewise, we have some countries that indirectly ban surrogacy through related law. So no special law, no explicit banning of, no explicit ban on surrogacy, but they do not allow it because they enforce other laws such as anti-trafficking and other criminal laws, or the Philippines, for instance, by applying the general provisions on contracts and family law. And in the Philippines, for instance, we have our civil code, which requires that the object of the contract be within the commerce of man, meaning that their ownership is transferable. And so I was thinking, since the Philippines has no law, express law on surrogacy, if this issue was before our court, the court would probably consider the agreement void since its object is the use or rent of the surrogate's womb, in which case the surrogate mother and the commissioning father will be considered the parents of the child, no different from two unmarried persons who have a child outside of wedlock. And if the surrogate mother is married, then the court would likely apply the presumption of legitimacy, meaning that the child is the child of the surrogate and her legal husband. Now, this will be subject to the surrogate's surrogate mothers' husbands filing an action to impugn or to question the legitimacy of the child based on scientific proof. But if the husband doesn't question it, then the presumption will be applied. Now, we also see that in other countries such as Myanmar and Malaysia, surrogacy is legal or illegal depending on certain circumstances, one of which is the party's religion. For Muslims in Malaysia, for instance, surrogacy is expressly prohibited by rulings or fatwa issued by the National Fatwa Committee in 2008. It says that it is not permissible for the sperm of the male of a married couple to be implanted into the egg of another woman. No Asian country that I studied leaves surrogacy to private ordering or wholly to the negotiations of the party. And I think that this is very good because while surrogacy pertains to choices that are personal and intimate by nature, it implicates a whole range of legal and ethical questions that are quintessentially public in character. In conclusion, what I see is a trend in Asia to ban commercial surrogacy. The triggers for these changes are mainly highly publicized incidents that spark public outrage, like the baby magic case in India, the baby Gami case in Thailand, and the Davis Charles conviction in Cambodia. If we had time, we could go into each of that, but we don't. Suffice it to say that India, which expressly allowed commercial surrogacy, recently amended its laws to ban the practice and allow only altruistic surrogacy. In Thailand, which was a haven for commercial surrogacy, the practice was banned in 2016, and only altruistic surrogacy for heterosexual couples is now allowed by law. Another country which was very open to surrogacy, which absolutely had no regulation on surrogacy, was Cambodia. But all forms of surrogacy was banned. All forms were banned by the Ministry of Health in 2016, and the Justice Ministry's unilateral action to forcibly stop all surrogacy procedures continue. Even legal experts in Cambodia agree that the current ban falls short of an actual law against surrogacy. Now, let's look at the rationale and consequences of the ban.
Elizabeth?
There are many reasons,
Elizabeth?
but one is the, yes? Time's up?
Yeah,
Oh my God.
already, but I'll give you 1 minute, just
Okay,
so that
1
we have
minute.
time.
Okay, so the child's right to identity, which will include the question of citizenship, whether the country where the child is born follows jus soli, jus sanguinis, or by descent, and the state, and this may result in the statelessness of children born out of ISAs, and also the question of legal parentage, without uniformity of laws or ambiguity in the laws, then we may end up with parentless children when there is non-recognition by the state of commissioning parents. Though the ISA is legal in the state of the surrogate mother or the lex osi contractus. This can also result in limping parentage. And another consequence is the child may have parents, but in countries where there is a differentiation of rights based on the status of the child as a marital or non-marital child rather, then there might be a different right to the use of the surname, support, custody, and succession. In China, though, they said that even if surrogacy contracts are illegal, the fact is that this does not change the fact that the child is recognized as a person and entitled to all his legal rights. In the Philippines, other than surrogacy, we also look at adoption and the new law on foundlings to see that indeed there are so many issues on the right of the child to identity within family relations. Thank you so much.
Thanks, Elizabeth. I gave you the impossible task to cover a region already on just one topic. And you can see that it's very complex, and yes, all the identity issues that stem from the issue of surrogacy, it's linked at every single stage of the process. And now I'd like to introduce you to a dear colleague also, Karabo Oza from the Centre for Child Law, who will speak to us about the child's right to identity in the African region. So thank you, Karabo. I think, Elizabeth, you just need to stop sharing your screen, and then it will mean that Karabo can share hers.
Okay, sorry. Am I still sharing my screen?
Yes, you just need to go down to the bottom to the bottom button where it
Stop
says
share.
share.
Sorry.
Exactly, no problems. Karabo, if we could have you now. Thank you.
Thank you, Mia. Good afternoon, and hello to everyone. I don't have a PowerPoint presentation. Please forgive me if I keep touching my neck. I have a bit of a sore throat. It's getting to winter here, so it's been a bit of a hectic. So it's been great listening to everybody and the different approaches, but what I will present is taking us back to the first presentation kind of of Professor Todorova, just sharing what is the legal framework and some of the challenges that are faced or appear on the African continent in relation to this issue of preserving the right to identity in different forms, in different spheres of family law and other related sections of our law. Obviously, I'm mindful of the time that is limited. So I'm based in South Africa, but I'll try to give examples of other countries on the continent as well as I go through the issues. The first thing I want to point out is the fact that obviously the UN CRC applies equally on the continent to countries that have ratified it, which are the majority of the African countries, including South Africa. And what the countries have done mostly is to try and also domesticate the provisions so that there's respect and promotion and protection of children's rights. So in particular pertaining to the issues that we're discussing today, we have also on the continent, the African Charter on the Rights and Welfare of the Child, which if you look at it, has quite a lot of similarities to the CRC. And there's also a lot of history about how the treaties were more or less drafted around the same time and some Africa-specific issues that are dealt with in the African Charter on the Rights and Welfare of the Child versus in the UNCRC. So the starting provision that I wanted to just highlight is something that everybody has kind of touched on, which is very crucial. And for the African continent, still a very problematic issue, which is the right of a child to a name and nationality, something that we definitely, if you are in a civilized country, you take it for granted that births are registered, there's a civil registry. When there is adoption, when there is any other process where a child needs to get into alternative care, that there will be proper recording of who were their birth parents, how did the parentage change from one set of parents to the new and all those things. But unfortunately, on the African continent, we are still lagging behind insofar as registration of birth is concerned. And this has an impact on a lot of areas pertaining to also when children are moving, are displaced because of violence, where children, for instance, in other areas, we have issues with child marriage, and there's issues about the fact that because there's no birth registration, you can't prove that the victim is actually a child. So Article 6 of the African Charter on the Rights and Welfare of the Child is the one that highlights the right of children to have a name and nationality and to have their birth registered. And because of, as I said, the challenges, the African Committee of Experts on the Rights and Welfare of the Child actually issued a general comment on this very article, trying to guide countries states as to how to proceed to ensure that their laws are enabling, their laws make sure that birth registration and nationality of children are preserved in a way that's child-centered. I say that because one of the areas where there's been quite a lot of litigation in South Africa, particularly, but also in countries such as Botswana and Kenya, is the discrimination against children born to unmarried parents, where you find that only mothers are allowed to register children, or in some countries, you find that if a father is unmarried, they're not allowed to be automatically on the birth certificate. So if such a child gets adopted, then it will be a problem. And we had a case in South Africa where an unmarried father years ago, his child was put up for adoption and the law did not recognize them. And actually he had to fight to change the law, but unfortunately did not benefit from that process because the law was not retrospective. We have other countries such as Swaziland where you can, nationality cannot pass through a mother. So those are some of the challenges that we face, and definitely those do have an impact then on how you ensure that you preserve the identity of a child before we even get to, all the other processes that come insofar as a child being adopted or, all those processes and alternative care processes. So yes, I mentioned this, it's General Comment 4 of the African Committee of Experts on Rights and Welfare of the Child that has very elaborate provisions about how states must approach the issue of birth registration and become more enabling than creating barriers. We also have then Article 18 that has a lot of provisions about supporting the family. I think we heard also from the young people that presented in the first sessions about the challenges pertaining to how they're approached by states when there are family challenges is mostly, it seems like they jump too much to removing children. And when you look at the African Charter on Rights and Welfare of the Child, you have Article 18, Article 19, and Article 20 that deal with protection and support to the family. They deal with how parental care must be promoted and the state's obligations to ensure that so that children are not necessarily deprived of the family unit. And then also clearly sets out what are the parental responsibilities that are on the families. We have a challenge, and I think also it's a global challenge currently with migration. And we know that children who migrate also are at risk of losing their original identity as they move. And there is a big issue there also pertaining to how do we preserve that. And when they, for instance, I'll give you an example of South Africa, which is a receiving country, particularly for children coming from neighboring countries such as Zimbabwe, Zambia. We have a challenge because we work on these issues of children who are migrating, that tracing and tracking processes are very complicated. Issues of resources to enable that, to ensure that you really do a proper tracing, you really preserve the information as you're trying to take care of the child in the South African alternative system. So those are some of the challenges that we face. And again, because children don't migrate with their passports in their hands, if they are regularly migrating and they're running away from hunger, or some of them even following family members and they come in irregular means, and that becomes quite a practical challenge. I've worked on this issue for the past 15 years and trying to come up with a system where we could centralize information. And I must also mention that sometimes children don't want to give you the real information, right? Because they don't want to go back to their families. And those are some of the issues that when we're working on these areas we face particularly, and how to navigate that is something that must be done on a case-by-case basis. Obviously, granted, there should be some law and policies and guidelines and SOPs that are standardized, but we do find that you can never really use a one-size-fits-all when it comes to these issues. And then we have Article 25, which is the most detailed article about what should happen and what are the state's obligations when children are separated from their parents. And this is very important for the discussion as well, because it talks to when you are going to remove a child, when you are considering those alternative placements, how you preserve the information of the child, how you try to reunify, and if children have to be permanently removed from their family, what the obligations are in relation to preserving that. So that, insofar as the treaty is very clear, and if one does a kind of a desktop search of most countries on the continent that have child-specific laws, Children's Act and stuff, you will find that most countries have actually tried to align to the African Charter as well as the CRC. However, implementation is where the big problem lies, insofar as preserving that information. And that we even see here in South Africa, where particularly I can mention when it comes to adoption and information that's preserved, the law is very clear about what must be kept, when can it be accessed by children, and when can it be accessed by adoptive parents. However, we've had quite a number of cases where that is a struggle, and particularly historic information is a problem because we haven't digitized our information, and that is a huge risk to the children who may come as adults, or now the children who are advocating for their ability to access the information pertaining to their origin. So that is one other area where we find that we do have serious challenges. I think when it comes to the most controversial, I'll put it that way, and challenging area, which I think Elizabeth was focusing on, which is the use of ART and surrogacy. On the continent as a whole, we still have a long way to go. South Africa itself has a chapter in the Children's Act that provides for how we deal with surrogacy. There's laws about how we deal with donation of gametes and stuff. But as was presented earlier, I think that was colleagues from France, we have donor anonymity across. You cannot really access information that's identifying unless if you bring a court application, but nobody has done that per se. And that is something that is going to continue to pose a problem, particularly that recently we picked up that there's a migration from other countries to try and come onto the continent to make use of the services on the continent for, you know, I mean, in the past we had a lot of inter-country adoptions, but now there's an increase of the use of surrogacy. And other African countries are even slightly behind South Africa because they don't have legislation. And that is definitely something that is of risk to children insofar as what is preserved, how is preserved, and how will access be enabled. And you know, if you mentioned that if one day we want to have retrospective laws for access, what will be found there? Because even here in South Africa, we are considering now doing research to really get permission to look at the records and see what is there. And if you have to have a law that enables children to access information, what will they find actually there? Because I don't think that this has received the requisite attention that is sufficient to deal with the issues.
Hey, Carabo, if
yes,
I can.
I'm wrapping up. Yes, I'm wrapping up. Thank you. Yeah, so I think I was going to say that I think we have a lot of similarities with the other countries. You know, as a continent, we still have a long way to go, and there's a need for investment in research and talking to the people who are affected directly by the issues in order for us to change the laws in a way that will really enable and be protective of their situations, and dispel, you know, the worries that people have that if you enable openness and access to information, that might be problematic. Let me stop here. Thank you, Mia.
Thanks for that, Carabo. I'd like to give the floor to Olga to speak about European developments, but we can see that each region is tackling identity from a different angle. There are many, many issues that are the same for all regions, but there are some specific ones as well. So Olga, if you'd like to do your presentation now, that would be great. Thanks.
Thank you, Mia. I just try as quickly as possible to share the. Yes, here it is. So good morning, good afternoon, good evening, whatever it is. And it's so great to see so many good friends, at least at the screen. As has been already said here about child right to identity a lot, and all the related articles of the convention have been analyzed. So particularly in Velina's presentation and other speakers' presentations. So I will do my best not to be repetitive, and I will skip the beginning. So I will move straight to the theme, child right to identity and family relations from a European perspective. And I would highlight very different family-related issues of child identity that are topical in the European context. So these are birth registration, child abandonment, adoption, assisted reproduction, establishment of parental relations, disappearance, child abduction, parental change of gender, living in a new family, and children on the move. And of course, due to shortage of time, I will not be able to discuss all these issues. I will almost completely skip some of them, and because they were either well known or properly already discussed today, but I will just name them for the sake of consistency and indicate that these problems do exist in Europe. Others will be covered briefly, some of them in more detail. So birth registration, we all know that it's a problem, and if there is no birth registration and proper documents, the child legally doesn't exist, which leads to numerous child rights violations, often very, very serious. But in the European context, I will just highlight that it is topical based on CRC committee's recommendations, It is mostly topical in with regard to migrant children, refugee children, Roma children, those who live in remote areas, and situations when the state require payments for registration, usually for late registration. You see the reference to the concluding observations. As to child abandonment, I would emphasize two sets of situations. Regrettably, I'm not able to go into the details. And the first situation relates to cases when a woman abandons her newborn child in maternity hospital or clinic and signs a paper that she will keep her name strictly confidential. There are two cases, two judgments of the European Court on Human Rights, well known, just to remind them, Odievre versus France, where the European Court didn't find a violation of Article 8 of European Convention on Human Rights. By the way, the committee at the dialogue with France in 2016 recommended the government of France to consider removing requirement of the biological mother's consent to reveal her identity and to increase its efforts to address the root causes that lead parents to choose to use confidential birth. And another case is Godelli versus Italy, a case with absolutely similar facts as Odievre, but where the European Court on the opposite found a violation of Article 8 of the convention. And these two judgments demonstrate the difficult dilemma of competing interests, the child's on the one side and the mother's on the other side. Baby boxes, it's of course absolutely against child right to identity. A lot has been said on that matter, so I will just note that some time ago the committee shifted from, in connection with the baby boxes, shifted from using the term anonymous birth to confidential birth, which is considered more appropriate. Adoption, of course, again, a lot has been said about adoption, and with regard to European context, the issue mostly relates to secrecy of adoption that is fixed at the legislative level, and it is reflected in the concluding observations. It's of course quite understandable that until secrecy of adoption is cancelled, any campaign or any activity that would explain the importance of for a child to know the truth will hardly be effective. Particularly, I like, as to committee's recommendations, I particularly liked recommendation made to Switzerland recently, to ensure that all children, including those adopted in the past, receive adequate support to know their origin. Now we move to assisted reproductive technologies and surrogacy. Very briefly on a position of the committee, it is expressed in several concluding observations. It is absolutely clear and unambiguous. A child should have access to information about the child's origin. I will not go deeper into the discussion of committee's position. It's clear, but I would like to draw your attention to a very interesting, from my point of view, case, JABS versus Costa Rica. This is the only, so far, the only case related to surrogacy considered by the committee under the third optional protocol on child communication. In this case, committee found the communication inadmissible because it was manifestly ill-founded, but it's still worth mentioning this case because there was a very interesting angle. The issue was whether it would be possible or not possible to reflect that reflect the name of the egg donor in the surname of a child. The child was born by gestational surrogacy in the US and received a birth certificate in the US, but this birth certificate was not accepted in Costa Rica because prohibition contained in national legislation. So if you are interested, I invite you to look at this case.
Olga,
assisted reproduction.
Olga, yeah. Olga, sorry, it's already, your time's gone. You've got a minute. It's gone so quickly.
Okay.
Yes.
So assisted reproduction, gamete donation, perhaps I will leave it for questions. I would just say that there is reference to the study, excellent study, which shows complete diversity of a situation with donors, whether it's permitted, not permitted, except permitted, not permitted, the result is that still there is trend to allow access of children to that information, and surrogacy access children or adults to information on surrogacy not properly regulated at all. Establishment of parental relations, I will skip, but it's clear if parental relations cannot be established, it's hardly possible to speak about child rights to identity. Disappearance, I will refer you to a very interesting case considered by the committee under the optional protocol. We call it stolen baby case. It's particularly interesting because the alleged disappearance of the child happened before the convention was adopted. It was in Spain in 1985. So basically that's it. Katarina told everything about child abduction. Parental change of gender and the consequences for the child not regulated or not properly regulated at best. Children living in residential care, there was also discussion, they mostly lose their identity because they lose contact with the contacts with their parents, and children on the move. The most saddest, the saddest situation that we now have in Ukraine, where hundreds and hundreds of children were separated with their parents, families, and there is serious doubt that their identity would be able to restore. But I do hope that this devastating situation will be over soon, and at least some of these children would be able to reunite with their families. Thank you, Mia. Don't kill me, please.
I will definitely not. Thank you, Olga. It's an excellent presentation, very ambitious to cover all those issues in 10 minutes, but the presentation will be on our website. Thanks, Olga, for that preparation. And now it's an honor to welcome Eduardo Rezende Melo from the International Association of Youth and Family Judges and Magistrates, who's based in Brazil, to give his presentation on the Americas. Thank you, Eduardo.
Good morning, everyone. I'm very pleased to be with you this morning. I would like to thank both Mia and Cristina Baglietto for this invitation. I made a short presentation. Let me check if I can share properly with you.
Yep, we can see it. We can see it.
So I'm going to address child's rights to identity in family relations in a Latin America's perspective. As you know, Latin America faces a lot of challenges, social challenges in the application of family law, and especially in child protection. And I think it's not possible in our region to consider the legal framework or without consideration of the social reality of these children, because this has had ever an impact on how the law was considered by judges and legal administration. And it is important to see how the legal framework moves with these social conditions. So in Latin America, we have a lot of challenges concerning child identity, not only children without birth certificates, around 3 million children, and this proportion increases in remote areas, especially among indigenous people living in the forests. And teenage pregnancy is we have a high level of teenage pregnancy of 63 births per 1,000 adolescents aged 15 to 19. A lot of children left alone or under care of another child below 10 years old, and children without access to child education, to primary education, and also lower secondary education. So this situation that is very related to poverty brings other issues like high rates of homicides in Latin America. It's 5 times higher than the global average. And when you consider that this homicide is affecting teenagers who have also children, this has a huge impact on child identity, not only of the teenagers themselves, but as well of their children. And these rates increase a lot among minority groups. We have 72% of children aged 0 to 14 years old living in poverty, and 2 out of 5 children have their rights not fulfilled. And 240,000 children grow up in residential care institutions, of which 10% are under 3 years old. So in Latin America, the impact of social inequalities on the right of child identity is very high because in a certain way, neglect and lack of family resources were and are historically intertwined and considered as a reason for removal of children from their families and placement in alternative care without due consideration of the state's omissions. So we have a historical relationship on how family law, without the consideration of the social conditions, was applied in an unfair and unequal with unequal outcomes. So social inequality is expressed not only by poverty, but also by the lack of services and facilities to support families in their needs and to grant access to rights by children, such as education, social services, and health programs. And besides that, we have a structural racism perverting interventions. We have a huge impact on disparities of rates in several areas, such as residential care. For instance, it's very high, this proportion, which is bringing to the debates the colonial approaches and how we could deal with these situations without this kind of perspective. So family law and child protection in our region has evolved not only in an individual perspective, but also in a social perspective. So we have from one hand, a lot of social policies that governments have been creating to try to decrease the social inequalities that are marked or emblematic in our society with conditional cash transfers to decrease the situation of poverty, and the perspective change on the way that a right-based approach on family interventions could have an impact in this situation, with an emphasis on preventive and universal social policies for families, granting rights and citizenship instead of a focus on substitutive care for children. So in case of violation of rights, through an effort in the region to recognize the state primary liability in the duty to grant children's rights in some countries. This has brought to our region the possibility of using collective and structural actions within the context of family relations. So how to provide services to grant rights for children in their families and avoid that these situations could impact their rights to identity, both in their families, when they remain their families, and when they are removed. So the increase in social awareness of these inequalities and structural roots, such as gender, racial, culture, has a huge impact in our region. And we are discussing how participation, this is a large debate in the region, how the population can participate in the discussions within the judicial system, with public hearings when all the situations are at stake, to grant opportunities and democratic change, including for children. So we have this challenge of universal policies, but we have also some challenges on how to focus this universal approach on singularities. So birth registration, as I said, is a challenge due to the disparities of the occupation of the territory. So we have a lot of initiatives with the improvement of integrated services between health facilities, registration services, and increased use of technologies like online civil registration, itinerant services to reach the population for birth registration in distant areas, such as indigenous populations. And these itinerant services is expressed also within the judicial system. So the judges travel in boats to reach these areas to grant access to justice to these families. So we cannot consider child's identity without rebuilding how the state is going to provide these rights and how the judicial system is going to apply the law in a context of proximity to this population. So the supportive programs for mothers who demand paternity recognition by the alleged father demands that the services go to the population and are closer to the population to grant this possibility. So also an increased recognition of diversity in family configurations, including LGBT families, and modalities of and diversity of support and social and health services. And diversification of modalities in custody regulations and in supportive programs for mediation, including the participation of children for family support programs and supervised visitation in the justice system, is also provided to grant this possibility of contact with their fathers. So normally we had this situation of mothers, the prevalence of mothers as those who host the custody and without services to provide a more equal relations between the child and both of their parents. And we also, I saw many mentions of the gender change of parents, but we also have the situation of gender change of children and the respect of their own identity, specificities on gender, like name changing, hormone treatment, and how social names and the possibility of their recognition in society can be applied. As we have had also these structural racism perverting interventions, we had also the need to discuss interracial adoption and its special challenges for children who are in alternative care. So how can we provide a family for those children who were deprived of their original birth family and who are not accepted by most of the adoptive families who want white children. So we are facing also some cultural challenges related to age, recognizing early childhood as a special category and the need of specific policies in family programs for them. especially. Yes, I'm finishing.
Thank you.
The move from, there was a majority of institutional services in the region, and in the last decades, we are increasing the number of foster care programs. So just to finish, we are in, I would synthesize my presentation saying that we are trying to repair the wrongs of the past and trying to do it right in the moment. So search for origins by adopted children who have not had their rights recognized at that time. We're talking about how adoption can be fair in this context, and how children are analyzing their own history in this social context. So a need to reconfigure all the adoption system in the region, recognizing also the possibility of open adoption or adoption with context, and recognizing violence in sex reassignment of intersex children, possibility of third gender in birth registration, and of change permission of sex registration. Overcoming sexual normative patterns to allow parents to have a loving and caring interaction with their children without pathologizing them, and increasing awareness and recognition of institutional violence by the state, including judicial intervention in various areas. So children deprived of liberty, lack of supportive parents of children, parents deprived of liberty, and how they can have a caring relations with their children, lack of supportive programs for parents with disabilities, and the need of participatory, integrated, and supportive and preventive methodologies to deal with families and children. Thank you.
Thanks you, Eduardo. I would never dare to interrupt the judge if I was in his courtroom. But thank you for that. You clearly know a lot about the right to identity based on the cases that you're working on, and because of your expertise in the region. So thank you for that. And now I give the floor to Dr. Sharon Petal, who is a clinical psychologist, as a person that is going to comment on the presentations that we've had before us. And then hopefully we have time for just giving everyone in this session one last word, one last statement to conclude this webinar. Thanks, Sharon.
Okay, I'm going to be impolite and not greet anybody particularly, but what is fascinating is thinking about how all these laws and policies and conventions impact on individual families and individual children, adolescents, and young adults, not only during that part of their lives, but throughout their whole lives. And as somebody who's been an expert in family proceedings and in clinical practice for 40 years now, I think there's almost every single situation that has been mentioned I have dealt with. And I think that what we need to think about, as I try to move my PowerPoint one step on, there we are, is that families and carers actually have to think very seriously about what they're doing on a day-to-day basis, that we're talking about addressing identity through the truth and the honesty of the adults who are looking after children, as well as the care and the love that they offer, which means that they have to accept that person, that child, including their history, every bit of their history. And we have to accept that adults can have and deal with their feelings well, and that all those involved may have many feelings and sometimes conflicting feelings, which is not only okay, but it's also understandable. We privilege aspects of identity. We have to hold a space for the reality of another family, of other people and places and people lost. We have to hold that space for our children, including the people that we don't even know, such as donors, and the current relationships, which is a difficult balance. We have to honour heritage and language and culture, and having access to information and documents that reflect reality. Story isn't always easy or It's often difficult and uncomfortable. And my question is, for whom? Is it for the child or the adolescent, or is it actually for the parents and the adults who are struggling themselves with something about it? It's not always something to celebrate. We all know about maltreatment stories, about incest babies, about children trying to grow up in other families or within their extended families where there's been intrafamilial murder. Growing up with part of your identity being somebody who is a murderer or a rapist is a very powerful organizer of identity unless it's handled well. Children who've been abandoned, children who grow up and know that their families of origin have stories of war, displacement, multiple losses, and becoming refugees, losing their country, their friends, their home, everything that is familiar to them. So what do we need? What do they need? Need access to informed psychological support and therapeutic intervention without the need for a diagnosis or a psychological problem. It needs to be for the whole family, which might involve more than 2 generations. It needs to be for parents and carers, and if appropriate, for school and residential care staff. And it needs to be accessible for children, young people, and also when they're adults, as these issues resurface in a different form. Resources should be available so that the process can be started when children are very young and the adults around them can be proactive. And I will briefly say something about what I think that sort of service should be like, and how after 25 years, I actually hope for this, on the 6th attempt, I will be setting up something like this, primarily concerned with donor-conceived families and donors and surrogates, etc., but also to offer services to people with complex identity stories. So these services should be easily available and developmentally appropriate. They should be non-stigmatizing. They should enable and support adults to gradually unfold stories to avoid a sense of betrayal and lies, to avoid late surprise revelations which can fracture identity and have the potential to create ruptures in significant relationships. They should have a range of interventions so that young people can feel safe enough to explore the meanings and ask questions, either within the family and or individually, and where their varied and changing feelings are acknowledged. These interventions should include groups in which children and young people don't feel alone and come together meeting other people like me with similar but different stories, because all of those children and young people have to come to terms with facts and feelings about their story or their conception and incorporate those into their developing identity. So as the laws and the conventions try to catch up with what we humans actually do, we also need to think forward and consider what those people and those families need in the longer term, because that protects people's emotional, psychological, and mental health. And if we started thinking about those things early on, we might find ourselves in less of a global pickle, I think. It's probably the gentlest way to say it. I'm going to stop there, Mia. I know you're keeping time and I'm going to give you some extra.
Thank you. So what I'd like now is for all the panelists in this session, starting with Elizabeth, then Carabo, then Olga and Eduardo, and ending with Sharon, if everyone could just give me their one dream or their one takeaway of what they would like to recommend to states in terms of how to preserve or re-establish the child's identity. Elizabeth, if I give you the floor. If Sharon, if you could stop sharing your screen, that would be great. Thanks.
Yes. Well, in the Philippines, although we haven't done so much about surrogacy, I am pleased to report that the Philippines has in fact passed recently a law on foundlings. So now we give foundlings, or a child who is found without information of birth and parents, to be given the rights of a naturally born citizen. And So I think this is so important, and I hope that states, the Philippines included, and others in Asia will continue to pass laws and of course implement them judiciously so that the rights of the most vulnerable children are protected. Thank you.
Thanks, Elizabeth. I love that promising practice from the Philippines. Carabo?
Yeah, I think the most left behind area on the continent, not only in South Africa, that needs to be addressed is the regulation of ART and the rights of donor conceived children. There's an urgent need to review the laws, particularly in my country, which is something that I'm looking at, and also on the continent, because most countries that are getting somewhere, and I think our last speaker said it, that when you review now the laws and policies, you now know more about the humans that are affected by it, and the law must then start reflecting that. That is something that is very crucial for us to do. Thanks.
Thanks, Carabo. And Olga? Olga, you just need to turn on your microphone.
Sorry, thank you. As to Europe, I think that there definitely should be a regulation that ensures access to information about origin and preservation of all the information on related to a particular person or child. Secondly, this regulation should be very carefully drafted, taking into account the sensitivity of the issues. Thirdly, children and families, but first of all, children should be provided, if needed, with very sensitive psychological support and counseling. And finally, the last point, we should be very careful with regard to situation, with regard to donors who consented on the condition of strict anonymity to donate their gametes before legislation is adopted. I'm not sure that we can force them, only persuade them, talk to them, explain the complexity and so on and so forth. But this is a separate also.
Okay.
Thank you.
Thanks for that, Olga. A good 1 minute. And also Eduardo.
I would bring an experience in Brazil. About child protection as well, but we had in the last decades we had a huge increase of population in alternative care, and it was a moment where the national government was organizing a national social assistance policy with a specification of all services. In 2009, we are in this movement of structuring all the policies, but we had this challenge of having universal policies and how to have a look at the specificities of the needs of the families. So the judiciary began an experience of doing what we are calling concentrated hearing, where all the situation of these families are analyzed with all the public policies together. So child protection courts have jurisdiction both on placement and the follow-up of alternative care, and we began to analyze how to make it mandatory for both the state on one side and the family to build a plan who could be executed in a more effective way, focusing on these singularities. And in spite of an increase of population in 7%, there was a decrease in the number of children in alternative care of more than 10% in this period. So we are bringing this approach to a preventive situation to avoid the placement of children and have a better impact in the family reunification as a whole.
Thank you for that excellent example, Eduardo. And just the last word to Sharon.
Well, I think it might make a difference if judges, social workers, lawyers, parents-to-be were asked the question, what are they consenting to on behalf of the child that they are considering at that moment, or the child who is not yet conceived or born? Because that is the party that is rarely properly consulted and whose views in later life are really going to matter.
Good food for thought for us to end this symposium, the very first ever. I think there is definitely room to have a second one, probably next year, given the amount of material that we've seen. Thank you to all the panelists. If my takeaway from this is that there is a lot of work left for us to do in terms of better protecting and restoring child's right to identity. And thank you to the panelists, and thank you to the participants as well. I hope that you've enjoyed this, and we look forward to sharing the recording with you. And if you have any questions, please send them to us after. Thank you, everyone. Bye-bye.
Bye-bye.